Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5277. And Citizens USCA Appellant versus Federal Election Commission and New Republican. Mr. Hancock for the appellant, Mr. Torchinsky for the appellee, New Republican PAC.
Good morning, Your Honors. May it please the court. Kevin Hancock for the appellant and Citizens United. This case involves a challenge to the Federal Election Commission's dismissal of two administrative complaints alleging campaign finance violations. First, in the matter involving the candidacy and soft money complaint, the district court erred by determining that the FEC's dismissal was unreviewable under this court's decision in New Models. Second, in the matter involving the coordination complaint, the district court erred by determining that the FEC's dismissal was not contrary to law. I'll address the soft money and the candidacy complaint first. The dismissal of that complaint is reviewable because the statement of reasons issued by the Federal Election Commission did not invoke prosecutorial discretion as an independent basis for the dismissal. Instead, the statement of reasons purported exercise of prosecutorial discretion is entirely dependent upon the statement's legal determination that deciding whether someone is a candidate requires probing their subjective intent.
How could it matter even if the blocking commissioners, the three commissioners, had invoked prosecutorial discretion because they don't act for the commission? I thought the commission can only act by a four-member majority.
Well, Your Honor, in our argument in the alternative, where we, we argue that New Models, that a court should follow the precedent prior to New Models because it conflicts with prior precedent. And so in that argument, we would agree, although our argument distinguishing New Models is operating under, the fact that New Models controls. We think New Models is distinguishable, so it's not necessary to reach whether, New Models should be followed under the Sierra Club precedent.
Let me tell you how I read the order and tell me if you think this is fair. Not 100% clear, but they start with an extended analysis of whether there is sufficient evidence of the soft money violation. And then after they conclude no, they talk about prosecutorial discretion, and they address several different factors: the lack of evidence that they've talked about, and then several more: the wide-ranging, costly, and invasive nature of the inquiry, the backlog of cases, the impending statute of limitations, throw everything in the mix and say prosecutorial discretion. Is that fair?
The one thing
I guess where I'm going with this is it seems to me like that would be a very typical analysis of prosecutorial discretion. Like you wouldn't expect it to be hermetically sealed off from the merits analysis.
Well, I guess I have a few quibbles with Your Honor's description of the statement of reasons. So first, I think the discussion of the evidence leading up to that last page, JA 290, that discusses discretion.
Right.
That discussion goes to whether then Governor Scott became a candidate in 2018. They discussed the poll that was conducted in 2018 and other possible indications. And then at the top of that last page, JA 290, the statement says it acknowledges that there's significant evidence of Scott's potential earlier candidacy.
Sorry, you're on
during the 7-month period.
You're on 290 now?
That's correct, yes.
Okay.
Second sentence from the top. So the statement acknowledges that there's significant evidence that Scott possibly was a candidate earlier during his 7-month term of chair, which occurred in 2017. And then the next sentence, the commission effectively says, well, we're not going to look into that because of a legal determination, because it would be necessary to probe his subjective intent to determine whether during that 7-month period, he in fact became a candidate. And because we believe that is the legal standard, that would require a long, costly, invasive investigation.
I mean, that sentence you just read bears on the merits, but it also bears on prosecutorial discretion, which is the topic sentence for that paragraph. So it just seems to me hard to unscramble.
I agree that the sentence bears on both, but the critical point here is the relationship between the legal analysis and the invocation of prosecutorial discretion. So I would compare that with what occurred in the New Models case. So there, the court was very clear that prosecutorial discretion was offered in that statement of reasons in addition to the legal analysis, and that the two were distinct, independent grounds for dismissal. And so the court there explains that, because there's no law to apply in analyzing the discretionary grounds, and if we analyze the legal grounds, we would risk an advisory opinion because the discretion is an independent basis for the dismissal. That's not the case here because the relationship between the legal analysis and the discretion is dependent. Everything springs from the statement's incorrect reading of the law that the standard is a subjective one. And the later concerns regarding the statute of limitations and so on and so forth are all expressly dependent upon the notion that a long, costly, and invasive investigation would be necessary to probe subjective.
But Mr. Hancock, on page 290, the second paragraph, I mean, that does not seem to be connected to any legal analysis. I mean, these are pretty much just straightforward concerns, right? The fact that there are a number of matters nearing the end of their statute of limitations, the commission's only had a quorum, was without a quorum for a long time, and so therefore really has to prioritize different enforcement actions. I mean, why isn't this a standalone invocation?
Because the particular, because the particular language used by the commissioners indicates a dependent relationship between the preceding paragraphs, legal analysis, and those discretionary factors. The commission in the first sentence again references the expensive and resource-consuming investigation that it thought would be required by its misunderstanding of the legal standard, the need to probe subjective intent. And then all the follow-on concerns about the statute of limitations and so on and so forth, all are a result of their understanding that this long, invasive, cumbersome investigation would be necessary. To put it differently, we don't know whether the commission still would have exercised or been concerned about those prudential and discretionary factors had it correctly understood the legal standard to only require an objective analysis of objectives.
I have a question about the scope of the stated discretionary factors in the blocking commissioner's statement as to matter under review 7370. If you look at the controlling commissioner's conclusion, it seems to me they only invoked prosecutorial discretion with respect to the quote allegations that Scott and his campaign committee failed to timely file candidacy and organization forms. So just a subset of those 7370 allegations, and of course also not including the matter under review 7496 allegations. It seems like there's a split even within 7370 with respect to what's being dismissed on
I think
discretionary grounds and what's on not.
I think that's correct, Your Honor. The statement does exercise prosecutorial discretion very specifically in 3 different places, including the place Your Honor identified, only as to the candidacy claims. And as the district court correctly recognized, did not exercise prosecutorial discretion with regard to the 7496 complaint, the coordination claims, and thus reached the merits of that complaint.
So if we were to rule even under new models, we should hold that the discretion applies only to the candidacy.
That's correct, Your Honor. I think the district court determines that because the candidacy claim is a prerequisite for the soft money claim, that exercise of prosecutorial discretion for the candidacy claim prevented it from then going forward and reaching the merits of the.
But that's a merits point with respect to the non-candidacy claims in 7370, right? As opposed to a threshold, no review because discretion.
That's correct. Yes.
But don't the subset of claims in 7370 that bear on the initial filings and the subset that bear on the soft money, don't they turn on the same question, which is when the governor became a candidate?
To find a soft money violation, it is necessary
Right.
to determine first that the governor had become a candidate.
So, you know, I noticed the same thing Judge Pillar did about you can read some of this language as invoking prosecutorial discretion for only a subset of 7370. But is there any logic that would support that? That a rational commission might think the soft money issue is just a merits one, and the paperwork filing issue is a prosecutorial discretion one? I couldn't think of one. I thought they all just flowed from the question when he became a candidate.
I'm not exactly sure, Your Honor. And for what it's worth, we did argue below before the district court that the exercise of prosecutorial discretion was just limited to the candidacy claim and did not also reach the soft money claim. You know,
I didn't think, did you argue that here? Your theory was mainly what you said earlier, which was the discretion and merits.
We were more focused on how prosecutorial discretion was not exercised as to the coordination claim, the coordination complaint.
Okay.
At the end of the day, I'm not sure the distinction matters too much, again, because of the need to determine Governor Scott was a candidate prior to then determining that New Republican or Scott may have violated the soft money ban.
You're talking only about 7370 because on the other one, there's some coordination claims following even when your opponent's claim, when he announced.
That's correct. And that's a critical reason why the district court erred with regard to the coordination complaint, because in footnote 2 of the statement of reasons, the commission appears to dispose of the coordination claims on a misunderstanding of the law, under the misunderstanding that it was necessary to find a candidacy or soft money violation first before finding a coordination violation. That is an error of law, and New Republican doesn't even claim that is correct, nor did the district court.
Can you say more about why that would be an error of law, assuming that the commission didn't dismiss that complaint on prosecutorial discretion?
Of course, Your Honor. So the merits of the coordination complaint do not require that the commission determine that Governor Scott was a candidate in 2017. Even assuming Governor Scott did not become a candidate until March 26, 2018, when he admits doing so, there still could be a coordination violation. There could have been coordination between Senator Scott and his agents after that date, or he could have coordinated prior to that and said, okay, when I become a candidate later on, here are my needs, here are my plans, here is the ad that I would like you to run. A request or suggestion is the legal standard under the commission's regulation. That could have occurred regardless of, even assuming Governor Scott became a candidate on March 26 when he admits doing so.
The point is that there were expenditures after he publicly became a candidate?
I apologize, Your Honor. Could you?
The point is that there were expenditures after he became a publicly announced candidate.
That's correct. In May and June, the super PAC, New Republican, made independent expenditures in support of his campaign.
Isn't the prohibition on coordination, doesn't that apply only to candidates?
So the standard is not clear. So Senator Scott became a candidate. So that's right. Undisputed.
Yes.
I don't think it's clear whether it's required that Senator Scott had been a candidate at the time of making a request or suggestion. It could be sufficient that he became a candidate later on. The commission was presented with that question in the Senate Majority PAC advisory opinion cited in the complaint and deadlocked. But even assuming,
So though under our precedents, to find something is contrary to law, it has to be an impermissible reading of the statute. So if the controlling commissioners believe there's a link between, the two different complaints, is that an impermissible reading of the statute? Maybe you think it's not the best reading of the law, but is it an impermissible one?
I think it's impermissible because it's undisputed that had Senator Scott coordinated with the super PAC with regard to the independent expenditures after March 26th, when he became a candidate, that would be a violation. And there's no.
I don't think anyone contests that would be a violation.
Correct.
But so before March, doesn't it turn on whether he was in fact a candidate at that point?
I don't think the commission has taken a clear stand on that question, but footnote 2 doesn't hinge upon that distinction. It just says categorically, because we did not find a candidacy violation or a soft money violation, we are required to dispose of these other claims.
I think under Orlowski and some of our other cases, to show that it's contrary to law, you have to show that there was an impermissible reading. And it seems here there's some ambiguity on your.
Respectfully, Your Honor, I think after that March 26th date, there's no ambiguity. There's nothing in the, stated differently, there's nothing in the regulation, the applicable regulation, that says that there has to have been like a soft money violation prior to the coordination. Indeed, these were 2 distinct complaints filed at 2 separate times. Presumably, the only reason why they're together in the same statement of reasons is because they involve common facts. They could have been separated out.
Suppose we agree with you that footnote 2 is not enough to resolve the coordination claim against you. What do you do with footnote 25, which seems to endorse a different and probably better rationale, which is the OGC found insufficient evidence to go forward at that time. They recommended holding it in case something turned up going forward on the other claim. Commission has just decided not to go forward on the other claim, so they only have the evidence that they have on coordination, and they say they agree with OGC. There's not enough there.
Well, I think there are a number of problems with footnote 25. The first one is that it incorporates footnote 2. It cites the footnote 2 and references what we believe is the error of law made in.
Just to identify the allegations of the second matter.
The general counsel's report that is cited by that footnote doesn't support the commission's dismissal because the general counsel did not actually recommend dismissal. The general counsel, the district court fundamentally misunderstood what the general counsel's recommendation was.
But I think what Judge Katsas is pointing out is in the circumstances of the recommendation, which said, let's go ahead with the candidacy claims, and this will follow along and maybe more things will come out. And if you read it that way, then the recommendation is no longer supported on that ground for these blocking commissioners when they've decided not to go on the candidacy.
Right. So as to the evidence discussed in the FGCR, we think it's not. So the general counsel actually cites to its discussion of the evidence. It says, as discussed above, the available information shows that Scott was involved with New Republican past 2017. And it refers back, and there are pages of analysis in the general counsel's report preceding that page, and I believe that page is 232 in the JA, discussing the relationship, the intertwined relationship between Scott and the super PAC. And then notes, well, we don't have direct evidence, we don't have evidence of Scott specifically making a request or suggestion. So let's wait, let's see pending this investigation whether new evidence comes to light. That doesn't reasonably support the idea that there's no reason to believe or dismissal, because the general counsel could have taken that step. The general counsel could have said, we recommend, no reason to believe, we recommend the commission dismiss these claims for lack of evidence right now. And
So the right way to go on that would be there's an error of law, send it back and see how the commission would act on this
yes, I think
in
that's
view
right.
of that.
Yes. In addition, they cite the affidavit submitted by Ms. Hazelwood. We think the district court also erred in placing weight upon that affidavit that the affidavit cannot bear. So first, the statement of reasons in the commission issued by the commission doesn't actually rely upon the Hazelwood affidavit as it pertains to the coordination claims. It states the claim in the Hazelwood affidavit, but it doesn't credit it. In fact, other parts of the FGCR discredit the Hazelwood affidavit. And the district court erred by claiming that the affidavit flatly denies any coordination. That is not what that affidavit does. That affidavit says Ms. Hazelwood did not directly coordinate with Governor Scott, but there are many other avenues to coordination that are not covered by that statement in the affidavit.
Well, it says neither Governor Scott nor any representative or agency of his campaign committee was involved.
And I'm sorry, Your Honor, if
I'm reading at the end. There's an extraneous not, which is clearly like a type.
right.
That last sentence.
In the last paragraph of the affidavit, Ms. Hazelwood does state that she conferred with other people contracted by the political committee, personnel, consultants, and counsel, et cetera. It's not disputed that the record demonstrates that Governor Scott, when he became chair of the super PAC, hired his former advisors and folks he had worked with prior to that to work for the super PAC. So folks that could have been his agent in terms of knowing his plan, his potential future plans for candidacy, were working for the super PAC. And Ms. Hazelwood says, I did confer with those folks.
We'll give you a little time for rebuttal.
Thank you, Your Honor.
Morning, Your Honors. May it please the court, Jason Good morning, Your Honors. Jason Torchinsky for New Republic. May it please the court. Controlling circuit precedent compels affirmance here. Both new models and Commission on Hope say that dismissals, even based in part on prosecutorial discretion, are unreviewable through this pathway. And as a result, the district court should be affirmed with respect to its dismissal of the complaint challenging the Commission's prosecutorial discretion. And then the district court was correct to conclude that 7496 on its merits was sufficiently reasonable to be accepted. And for that reason, this court should affirm the district court's.
It's really extraordinary and difficult for us not to have the commission here today. And I realize that also puts you in a difficult position. You talk about clear precedent requiring a dismissal where prosecutorial discretion is involved, but we also have to grapple with the Supreme Court's decision in Aikens, which held inapplicable Cheney's rebuttable presumption against judicial review of exercises of non-enforcement discretion, because the statute explicitly provides to the contrary. And in Aikens, as the statement of reasons said, the FEC invoked prosecutorial discretion, as the Solicitor General said, in arguing that case before the Supreme Court. There was an invocation of prosecutorial discretion there. And the Supreme Court in the decision addressed that prosecutorial discretion was not in the context of this unusual act where there's an equally divided commission, that Heckler doesn't apply. So we have some circuit precedent, and then we also have a higher court saying to the contrary.
Your Honor, I think Aikens obviously has been a debate on this court going back to the Commission on Hope cases and the new models cases. And I think Judge Rao in the new models 1 opinion really squarely addressed Aikens and basically said Aikens stands for the proposition that the petitioners there had standing to challenge it. It was
Right, but a fortiori, they have standing because the claim, notwithstanding an exercise of a claim of prosecutorial discretion on the part of the commissioners, is judicially reviewable in a private party suit and therefore redressable, right? So standing there brings in the question, what's reviewable and what's not? When can a private party sue? And if that's the premise for the standing determination, it's a necessary aspect of the court's holding.
I think the way I read that case is that the standing determination was based on essentially whether they were seeking information that they wouldn't otherwise have if they had prevailed in front of the commission. But on page 25 in Aikens, the court talks about how the court may well have, the FEC may well have dismissed had there been prosecutorial discretion asserted. And then, you know, the line that you quoted about saying that the FEC statute was different appears on page 26. So there's a little bit of an internal contradiction inside Aikens where it sort of indicates that there's prosecutorial discretion available to the commission, but then says, you know, the FECA statute's a little bit different. But I don't read Aikens to foreclose the FEC's exercise of prosecutorial discretion. And clearly this court
No, it's just saying we would have to send it back because on the correct view of the law, instead of us trying to divine what they would do on the correct view of the law, and that's very opposite to this case, right? We should send it back and see whether the commission would still have decided in the exercise of its discretion not to require the production of the information.
Right, but if the court had agreed with the view that prosecutorial discretion was foreclosed by the FEC, why would the court have suggested that the commission had the prosecutorial discretion option even upon remand? In other words, if that was
No, it's not that prosecutorial discretion is foreclosed. It's what's the implications for judicial review and for the private right of action. And what they're saying is they're sending it back. And when the commission, by a legally operative four member or majority vote, exercises prosecutorial discretion, then, you know, that is different. But here there's a statement of discretion by people not even acting, can't legally act for the agency. It's very odd to say we would use very deep deference to their thinking when it's.
Except that the way Congress has structured the FEC under FECA requires 4 affirmative votes to take an action. If Congress had wanted a 3-3 vote to proceed, it would have written the statute different. And I think that's where I sort of disagree a little bit with your perception or with your position that 4 votes were required to exercise prosecutorial discretion. That's not the way Commission on Hope or New Models interpreted.
Right, I realize that. And what I'm trying to understand is how the position that leaves us in, because I mean, you know, because I've written about this, that I think that the Commission on Hope took a wrong turn that was in conflict with our prior cases.
I mean, I think if you go back to the DCCC case from 1987 that then Judge Ginsburg wrote, you know, that was an interesting split because it was 3 to proceed, 2 for prosecutorial discretion, and one who abstained. And clearly they didn't have the 4 votes. So even going back to around the time of Aikens, this court didn't seem to take the view that 4 were required to exercise prosecutorial discretion.
But there, they reject in the Ginsburg-Starr nice decision, they reject Heckler. They reject the notion that there's nothing to review. They send it back and say, we need to know. You know, there's no bar in DCCC, no bar on review of a deadlock. They respond to the FEC, which said, this decides nothing. And they say, well, actually, the fact that they've said it's simply an exercise of prosecutorial discretion is not a bar to our review. So we're talking about a jurisdictional question here.
Great.
And the issue is, it's a gate to the private right of action. It's not that the FEC in any way lacks discretion whether it proceeds, but all of this, of course, has to do with what is the nature of what a private plaintiff needs to exhaust in order to proceed with the private right of action.
Your Honor, the private right of action sort of invocation in FECA was extremely rarely used prior to 2013. Over the preceding 40 years, I think one case had proceeded, and there had been plenty of deadlocks that had been reviewed by this court and found sufficiently reasonable to be accepted and not reversed on any kind of review of prosecutorial discretion.
Do you have cases of 3-3 deadlocks that were reviewed that way? I'd be really interested in that.
DCCC was 3-2-1.
But DCCC, we remanded. And we didn't say, bless the commission's action.
That's right. So normally, Your Honor, the commission would be here to defend itself. But what happened here was we didn't have a fourth commissioner available, or a fourth commissioner who declined to vote for enforcement. And there's a number of these cases going through. With respect to whether there have been review of 3 dismissals prior to 2013, I would probably need to submit a 28-J letter to the court because I don't have.
You said 2013?
2013, which was about the time that the one commissioner that the commission started declining to defend itself, post Citizens United.
Mr. Tracy, you're not arguing here that this court lacks jurisdiction over this claim. You're just suggesting that it's unreviewable.
Yes.
I misspoke. I actually apologize because that's an issue in the case.
Yeah.
Not about jurisdiction, but whether it's reviewed.
That is correct. Yes.
Thank you.
Correct. Prosecutorial discretion dismissals are unreviewable. It's not that the court lacks jurisdiction. It's just that they're unreviewable, essentially under as Judge Rao has pointed out, under kind of almost a separation of powers for deference to the executive agency.
See, that's what's so odd to me. And, my friend, Judge Rao, has written about this, and I, of course, will have an opportunity also to do so. But it's hard to understand how it would be a separation of powers problem to honor the commission's decision to stop wherever it seeks to stop and to allow a private party to pursue something with its resources that the commission chooses not to pursue.
But the private party provision only comes after a lawsuit like this is filed and the court determines that the commission acted contrary to law. And I think what New Models and Commission on Hope stand for is the proposition that judicial discretion or prosecutorial discretion dismissals aren't contrary to law because, as those courts have pointed out, there isn't an applicable standard or a justiciable standard for this court to evaluate when it looks at things like the commission cited in the statement of reasons, and they say things like, use of agency resources, approaching deadlines in other matters, approaching deadlines in the current matter, and what the agency wants to prioritize over other things. And I think both Commission on Hope and New Models stand for the proposition that courts aren't going to insert themselves into that executive decision making. And you're right, Judge Pillard, it might well foreclose the ability of private plaintiffs to take, to proceed through the step of being able to file a private lawsuit. But guess what? Congress is well aware of that. It's been the way that has been adjudged since FDCPA has been adopted, and Congress hasn't changed it. And
it's so interesting that you refer to, this is where it would be great to have the commission here. Did you say there was only, you said the private right of action was rarely used before 2013?
Before 2013.
And so here's another theory of what the interplay between private right of action and commission enforcement is, that Congress wanted the commission to enforce. They wanted the commission to be the primary enforcer. They didn't want a lot of private rights of action because, these are cases that are politically charged and they want to keep them under the control of an agency, but they also recognize they had to make the agency partisan balanced because otherwise enforcement could be politically dominated.
Yes.
So they're trying to avoid political domination of enforcement. At the same time, they put a private right of action in there because they want to avoid stonewall, right? But they designed the private right of action in this genius way. It turns out not to be so genius, but rather, at least where we're at today, not very functional. But if you look at the design, it appears that what they're doing is saying, look, FEC, you get every chance. If you're acting according to the law and you can manage to act in a nonpartisan way, in a bipartisan way, then you are the exclusive enforcer. It's when you act contrary to law and or can't get your act together to do something in a bipartisan way, that's going to open the door for private rights of action.
Your Honor, I don't think Congress actually intended it to say if you can't get your act together. I think, look, FECA is a unique statute, right? Because who are the subjects of the enforcement action? Members of Congress, right? There are candidates for the Senate, there are candidates for the House.
Well, there's also, we see a lot of
just
organizations that raise money.
Yes, but all of those involve candidates for office in some way, right? So, I think FDCPA is a unique statute because Congress is uniquely aware of its effects, its interpretation, how it's been sort of accepted or how it's been sort of used in practice, right? Because there's no member of Congress except perhaps an appointed senator who didn't go through the FDCPA process to get to where they are.
The under enforcement is a feature, not a bug.
Correct. And yes.
So my friend Judge Pillar and I may disagree about the meaning of FDCPA, but I think we both share our frustration that the FEC is not appearing in these cases. It would be certainly helpful if the commission were here. But can I ask you about the second complaint?
Absolutely.
So I am more skeptical that the second complaint is dismissed on prosecutorial discretion, because the commission suggests it is dismissing, the first complaint effectively, on prosecutorial discretion, and then they provide what looks like a legal reason for dismissing the second one. In footnote 2, they say that, if we dismiss the first on prosecutorial discretion, we are required to, that's a threshold legal finding for the second.
I think I read that a little bit differently. And I also would point you to JA 272 and 273, which is actually the certification of the vote. If you look at those pages, they failed by a 3-3 vote to dismiss the allegation under Heckler versus Cheney that he failed to timely file a statement of candidacy and he failed to file a statement of organization. But then when you look at sub C, sub D, sub E, sub F, and sub G there, where they're actually talking about the merits related to both the soft money complaint and the coordination complaint, which I view as different legal analysis. There's not an invocation of Heckler v. Cheney in the actual certification of the vote there. So I think in terms of parsing out what they dismissed on prosecutorial discretion and what they dismissed on merits, I think the trial court got it right, because a combination of what was in the statement of reasons and what was in the certification of the vote, there's a lack of citation to Heckler versus Cheney in the votes on the soft money and the coordination rules. And I distinguish those because, pretend there was a break in time, right, when then Governor Scott announced that he was a candidate for Senate. If he had been raising money for New Republican while a candidate, that would violate the soft money rules, but it wouldn't necessarily violate the coordination, right? It's the act of the advertisements that were aired in May and June that the appellants here are saying violated the coordination rules. And so I think there's a distinction between the soft money question and the coordination question that is critical. And I think the commission was struggling with that a little bit. And I think the trial court was struggling with that a little bit, but I view them as distinct allegations from each other, because you could have had coordination without the soft money out, right? If Senator Scott and his team had sat down with the super PAC in May and been like, hey, you run an ad on, issue A, and that'll be great, and I really hope you do it, and here's what I think you should say, that would have nothing, there would be no soft money allegation raising or spending there. It would be a coordination problem and an in-kind contribution to the campaign that would have been unlawful.
So though, on those claims, if that's not an exercise of prosecutorial discretion, then is it contrary to law?
No, because I think what the commission is saying is there was no evidence of any communication between Senator Scott's campaign and the super PAC related to the May and June ads. So on a complete lack of evidence, we are going to decide on the merits that it's not worth, that the commission shouldn't proceed to investigate when there's absolutely, we have a sworn affidavit from the executive director, and all we have from the complainants here is speculation. In their words, it may have occurred, it might have occurred, it could have occurred, but they have no whistleblower, they have no firsthand information. They base some of their allegations on press statements to the press by third parties who were not involved with the campaign or with the super PAC. And on the basis of lack of evidence, the commission properly concluded that there was nothing, there was no basis on which to proceed.
Is it your view that lack of evidence is an exercise of prosecutorial discretion?
I mean, I think there's a reading where you could say lack of evidence is prosecutorial discretion, but I also think there's a fair reading to say if there's no evidence here, we shouldn't proceed because there's no evidence here. But then do we review that under contrary to law? I mean, I think there is a fair reading of the statement of reasons where you could say both were dismissed on prosecutorial discretion and therefore nothing here is reviewable. I also think the district court wasn't incorrect to separate the two MERS and say one was dismissed on the basis of prosecutorial discretion and the other was based on essentially a merits dismissal because of lack of evidence. So I think you could actually read the statement of reasons either way, as we said in our brief. I also think it was entirely reasonable for the district court to read it the way it did and separate the two matters.
So if it was a merits determination, why is it consistent with law? Or why is it not contrary to law?
It's not contrary to law because all you need as a district court reviewing that is a sufficiently reasonable basis to be accepted. And I think when you go through what the statement of reason says about crediting the affidavit, the lack of any evidence contrary to the affidavit, it was perfectly acceptable for, if pretend this was a criminal case, for a prosecutor to say, look, I've got somebody saying this must have happened. I've got somebody saying it didn't in a sworn affidavit. The party saying that it must have happened is based on speculation and comments by third parties who have no firsthand knowledge. And the only evidence in front of me from anyone who has firsthand knowledge is a sworn affidavit subject to penalty of perjury. There's not enough here for me to proceed. And I think that was a perfectly reasonable merits determination, but you could also view that as an exercise of prosecutorial discretion.
You didn't defend it that way in the red brief.
I think in our brief, we acknowledged there was a way to read it that way, but I think the way the district court read it was entirely reasonable as well. So I think this court could read it either way, because either way we get to the same conclusion, which is summary judgment for New Republican and dismissal of the complaint.
Can I take you back to the first complaint and just assume we're going to apply? If we apply Commission on Hope and new models, do you, in order to prevail on Heckler versus Cheney, do you need to show that the exercise prosecutorial discretion is independent of legal analysis?
I don't think that I read Commission on Hope or new models that way. I think an invocation of prosecutorial discretion, regardless of how connected or disconnected it might be from any legal analysis, is sufficient to essentially require the court to acknowledge the exercise of prosecutorial discretion and not proceed.
Even in a case where the legal considerations and the discretionary considerations are blended together?
I mean, yes, I think that's correct, based on Commission on Hope and new models.
And your response, maybe I'm asking you something you've already answered, but I'm still stumbling on the message of Aiken, which seems to say if you have a blended discretionary and legal analysis, we don't assume we can disentangle, but we send it back with a correction of the legal. And so it doesn't, I mean, the threshold to that is that doesn't render it unreviewable, because then you end up having law that ossifies. So what is the mechanism through which the mixed in legal errors get corrected?
I think the answer is when there are merits dismissals by the commission on particular issues, those are reviewable under the contrary to law standard, and then the courts can set out for the FEC if they've gone beyond the bounds of the law. And like you had present here, in 7496, where the trial court said, look, there was a sufficiently reasonable explanation under the law to determine that on the merits, there was no coordination. And I think
sufficiently reasonable explanation.
I think the district court said sufficiently reasonable to be accepted is how the district court read this court's standards for the trial court review.
Right. And sufficiently reasonable to be accepted is from from our court.
Yeah, and I think that hold on, I'll tell you exactly where Leanne cited that. I think that goes to the Campaign Legal Center case at 952 F3rd at, I can find the exact page site, but the court quoted this court, which quotes back to DSCC, which is a U.S. Supreme Court case. Quote, in this deferential inquiry, we asked only whether the commission's decision was, quote, sufficiently reasonable to be accepted.
So yeah, it was DSCC where there was action, I think in that case it was unanimous. So the notion, or it was certainly a majority. So the notion that a standard of sufficiently reasonable to be accepted, which is a highly deferential standard, would apply to a non-majority blocking determination, to the content of it, just seems to me to have no rationale whatsoever.
I've never argued that Congress makes rational decisions when they lay out these statutes.
Where in the statute do you find that?
Where you find it is essentially where in the statute at 30109, where Congress lays out exactly what requires 4 votes, and dismissals do not require 4 votes. They only decisions to proceed require.
Right,
4.
but this wasn't a dismissal. This was a vote on a reason to believe proposal. The dismissal was separate, and it did happen by a majority vote.
Your Honor, I think there's an ongoing debate at the trial courts and here.
There is, but I'm just looking at the question whether there is a legal basis for the standard that you endorse, which is that we should look at the content of what the blocking commissioners say and ask whether it's sufficiently reasonable to be accepted.
I mean, I think that's been the practice at the trial court and from this court over the last 50 years of FICA. And I think, in this case, fortunately or unfortunately, we don't have the issue of whether they actually closed the file, because on the same day that they voted, 3-3 with the invocation of Heckler with respect to 7370 and dismissed 7496, they also voted 5-1 to close the file. So, we don't have that issue about whether closing the file is the act that triggers review or whether it's the other vote that does is not present in this case.
Well, closing the file is clearly the act that triggers review, because that's the time to sue runs from that, right?
Your Honor, I think part of the problem, and again, it's not present in this case, but part of the reason that some of these lawsuits are there with these 120-day lawsuits with the alleged failure to act is because the commission hasn't closed the file. The public and the respondents and the complainants have no knowledge as to whether the commission had any other votes on the matter. And again, not present in this case, but I think that's an issue percolating in a few other cases in front of us. Thank you, Your Honors.
All right, Mr. Hancock, I think we used up your rebuttal time, but we'll give you 3 minutes for rebuttal.
Thank you, Your Honors. Just a couple of points, and then I'm happy to be helpful in any way that I can, Your Honors. I may be misunderstanding, but I believe that the parties are now on the same page about reviewability not being jurisdictional. And so I would urge the court, even if the court were to see fit to affirm the district court on the reviewability issue, we think it would be proper for the court to still issue an opinion like it did in Orzac v. Sullivan, correcting the basis for the district court's dismissal to clearly state that it should not have been.
Is there any practical difference? I think you're right on the characterization. Just wondering if it matters.
I think there's a huge practical difference in that this area of the law should be clarified, in particular because, of course, jurisdictional arguments are not waivable. And so they can be raised at any point in litigation. And the Supreme Court in the Wilkins case
would matter in other cases.
Recently highlighted the importance of it. Okay, thank you. Also, I believe the parties are now on the same page that footnote 2 does in fact refer to the coordination claims. The district court in a passage claims that footnote 2 does not refer to those coordination claims. We dispute that reading. We think it's clear that footnote 2 must refer to the coordination claims when it says it's required to dismiss the other claims and cites the certification that includes the vote on the coordination claims. And as we've argued, we believe that footnote contains an error of law that forms the basis for that dismissal.
Is there any other error of law that you see in the analysis of the coordination claims?
Yes. So the weight put on the Hazelwood affidavit, the Hazelwood affidavit cannot support the weight the commission put on. And that was unreasonable for the commission to base the dismissal upon that affidavit.
You asked us to reverse the district court's dismissal of the case. If we agreed with you that the disposition in 70 is reviewable, why wouldn't we just go on to address whether the controlling commissioner's decision is contrary?
We think this court should do that. because the district court went ahead and actually did reach that merits issue.
Rather than point out the error and send it back.
Correct, because presumably the district court would just come to the same conclusion. So I think this court could just find that that's contrary to the law.
Thank you very much.
Thank you, Your Honors.
Thank you to all counsel. Case is submitted.
Case number 22-1242, Peabody Midwest Mining LLC and Michael Butler, employed by Peabody Midwest Mining LLC, petitioners versus Secretary of Labor, Mine Safety and Health Administration, MSHA, and Federal Mine Safety and Health Review Commission. Mr. Moore for the petitioners, Ms. Maltz for the respondents.
May it please the court. Case involves a number of issues, but it comes down to whether or not the two violations that the commission found were properly designated as unwarrantable, and whether or not individual penalties should have been assessed against Mr. Butler. Recognize what we have here. We are dealing with the actions of a mine foreman when the drilling crew who was drilling to find a location of another mine, if it was adjacent to or too close to the mine. He was called to the area. He had no idea what he was getting into. When he walked in, there was noise because the air was coming out of the borehole. He did not expect what was occurring. He had taken a maintenance foreman with him because he thought there was a problem with the drill. When he got there, he came into the area in by, and if I confuse anybody with in by and out by, please let me know. We did define it, but essentially it's a directional term. He came into the area in by the drill and walked up to the driller and said, what do we got here? The driller told him, and he said, what's the procedure? And he said, plug the hole. But what he did at that point is let the driller and his assistant try to go ahead and plug the hole. And what he did, and at that point, they were already starting the process of pulling drill steels out of the hole so they can push a plug in.
Mr. Moore, if you could just help me to understand some of the terminology here. Is it your position that the action of plugging the borehole is a type of ventilation work?
Yes, it is. Because while you don't typically, if you're up at the face of the mine and you have excessive methane, you can't do anything to stop that. But in this case, you can prevent the methane from coming into the airstream. So it is, in fact, ventilation.
Is it ventilation work in the meaning of the regulation? I mean, I understand it's an action designed to lower the levels of methane, but is it ventilation work?
Well, when you are doing ventilation work, you're doing any number of things. You are putting up curtains to direct air. You're putting up stoppings to separate airways. If you are dealing with areas of the mine that are sealed, you may well be installing seals, additional seals. If you are dealing with an area behind, which we don't have here, a longwall panel, you may be doing things to prevent methane coming out of the area behind the longwall panel into the airstream in the mine. So in that sense, if you're stopping methane, you don't normally have the chance to stop methane, but if you are stopping methane as you would, for example, coming out of a longwall gob, it's the same thing as I see it.
So ventilation in your reading includes plugging.
includes plugging in this instance. Now, recognize, of course, this is an unusual case, and the application of these standards to this are unusual. And that's the part of the problem with it.
It may be an unusual case, but the regulation seems just very clear. I mean, the one thing you have to do when the methane level exceeds 1.5% is shut down the electrical.
Well, okay, when they got,
You might have an argument that there's some atextual defense that if you have to violate the rule in the interests of safety, you can do it. But I don't see any argument that
well,
you're not within
it's
this
interesting because I was looking at, this involves 75-323C2. C1, which address,
C2 Romanet 2
yes.
says shut off the electrical.
Well, yes, but it's the collective C2. But C1 says if methane's over 1%, you're supposed to make changes and adjustments to ventilation. How you factor that in with C2 is an interesting question because of the reference to other work. It is interesting.
C1 is the one that's when it's 1%.
1% or more.
Right. So it's 1% or more. So within that, you know, if it's at non-dangerous but potentially mounting, then you make adjustments. But then 1.5, whether C1 applies up above 1.5 or not, C2 is clear. I think as Judge Katsas was saying, that everyone shall be withdrawn, power shall be disconnected, and no other work other than withdrawing people and disconnecting power can occur until the methane concentration is less than 1.
Everyone should be withdrawn except those who are permitted to remain in order to eliminate hazard.
Well, except those who are working to withdraw people and turn off power, I think is how the commission reads it, right?
That's the way I read it, but there is the C2 single I that says the people who are working to eliminate the hazard may remain in the area. And let's take the situation. They de-energize the drill and they remove everybody except those people who might be necessary to address the hazard. They could stand there, they can monitor it. We know that the methane was going up and down, and they could stand there and monitor it. If it went under 1%, they could then fire up the drill and go back to what they were doing. And the interesting thing is, while we keep talking about the commission and the secretary talk about 5%, we know it wasn't 5% most of the time because the drill would shut down at 2%. And in fact, the inspector said when they were trying to plug the hole and they were drilling, it was probably 1.1 to 1.2%. So we know that for at least the period where they were pulling most of the drill steel, the methane was under 2%. We don't know exactly what it was. We have the judge saying he can't tell how long it was above 1.5%. So we have a situation that they're trying to deal with. Now, the inconsistency that we have in this case is the judge says what Mr. Butler was doing was laudable, admirable, and he did it in good faith. And yet, the same judge and the commission then turn around and say, well, yeah, it was all those things, but it was aggravated conduct.
Well, because commission precedent only recognizes a defense where an operator has a good faith and reasonable belief that the cited conduct is the safest method of compliance. And I think that, you know, the ALJ is recognizing people do make mistakes, but that it is still a mistake in the sense that it's not reasonable under the regulation.
Well, I would disagree that it was unreasonable for two reasons. One is they're trying to prevent a greater hazard.
How so? The hazard is measured with respect to minors. How is it a greater hazard to turn everything off and leave? What's the hazard to humans?
Well, that means methane will keep pouring out.
Right,
And
with nobody around.
Well, yes and no. Because, all right, you evacuate the mine, let's say the methane goes out in a return and does what the inspector thought it might do, which is get sucked back into the mine on the intake, because both the intake and the return terminate out in the pit.
And I'm sorry, because we are taking the limited time. You said he's acting to avoid a greater hazard. And really the question I have for you on that point is, there are these two different defenses, the greater hazard defense and the diminution of safety issue. And you objected to diminution of safety because that requires a filing or a contact with MSHA that you claim was unreasonable. But the greater hazard seems to me to be the way around that cumbersome procedural requirement. But it also, I didn't see you raising that meaningfully before the commission, and B, even if you had, you have to argue that that all the elements of that are met, and I don't think you've met them here.
Well, first of all, I think the diminution of safety defense and the greater hazard defense really are one and the same. Because if I think application of the standard diminishes safety, that means there's a hazard from application of the standard that is frankly greater than what they're trying to do.
Well, so if they're the same, then there's precedent that the defense requires that the process be modified because the hazards of compliance are greater than the hazards of the proposed non-complying action, and that there's no alternative means to protect minor safety. And here the question is, why is it not a means of protecting minor safety to evacuate everybody and turn everything off?
Well, the means available to protect minor safety were what they were doing, which was putting more air over the air that was coming out of the borehole. And they did that by redirecting it with a curtain, and also by taking the air from the adjacent entry and directing it over to the drill area so there would be a full amount of air coming through there. They had the people from the adjacent section leave.
Was there coal production going on that night? It was unclear to me from
There was coal production. You should understand the drill is in the zero entry. And to get to the section, you would go over 3 or 4 entries to get to the travel way into the section. There was coal production, and in fact, it was in by where the drill was working. Now, they stopped coal production. They pulled the equipment back. They de-energized it, and they de-energized it, pulled the power out by.
So if the plugging had been effective that night, presumably they could have brought the people back. Was it in zone 3?
If the plugging had been effective, excuse me, and that people had been evacuated from the mine, while it's not necessarily clear from 75, 360, and 361 and 2, you would have done an examination of the mine. Now, I will tell you practically what would have happened. This happened at 2 o'clock in the morning. The normal free shift for the next shift starts at 5 o'clock. They wouldn't have brought those people back in. If they had plugged it. Now, let me also say, particularly with respect to Mr. Butler, he happened to be in the adjacent section. He was only a couple entries away. If he had been in the other section and they called him there and he'd come over, probably they would have had it plugged by the time he got there, without the things that he directed be done. It's happenstance. He did what he thought was the best thing to do. And obviously the commission disagreed, but looking at it, there should be consideration for the fact that he acted in good faith, though they disagree with it. And what he did was characterized as good.
Right. And I mean, these are not easy jobs. With respect to Mr. Butler's personal liability, you're not challenging the ALJ's application of the knowingly standard in North Shore mining.
No, we're not.
On
I
unwarranted,
think North Shore was wrong, but
You're not challenging that here.
Yes, that's not here.
on the unwarrantable failure, which requires some relatively high degree of culpability, does the inquiry focus on the reasonableness of how Mr. Butler read the regulation, or the reasonableness of his safety judgments, or both?
I think it has to be both. I haven't thought of what is required is aggravated conduct, and which is more than ordinary negligence. These two orders were designated high negligence, but as I looked at Freeman, I'm saying to myself, well, I'm not sure that that's enough. But having said that, I think the reasonableness of what he did and the reasonableness of the circumstance.
And I assume you give me the same answer as to Butler's individual liability to the extent there's a good faith defense.
I think you need a little bit more than aggravated conduct.
Mr. Moore, you mentioned in your brief, and you also mentioned today, that REI was in charge of the horizontal drilling, and Mr. Butler asked them their view. Would Mr. Butler or Peabody have an indemnification claim against REI if
No, not
if
really.
the
I mean, REI, as an independent contractor, stands in the same stead as Peabody. They are an operator as an independent contractor. And in this case, REI was a specialist.
and they were also enforcement was brought against them too,
Yes.
and that's been resolved.
Mr. Sharon was the one who was familiar with the plan. Mr. Butler, because he's normally involved with other things, was not familiar with it. Mr. Farron testified that he thought he was complying with the plan. Said it turned out it wasn't, but and they changed the plan afterwards. But anyway, but he wasn't charged. Mr. Farron was not charged individually, even though as the sole representative of REI, by any legal definition of agent, he was an agent.
Thank you, Mr. Moore. We'll give you a little bit of time if you want it. Morning, Ms. Maltz.
Good morning. Good morning. May it please the court. Susanna Maltz for the Secretary of Labor.
A little bit difficult to hear you. You might bring the
Could you
microphones.
speak up?
Yeah,
Sure, absolutely. How's this?
better.
Okay.
You can also bring the side microphones in. There's a lot because our system is not terrific.
Understood. Okay, please let me know if I quiet down. We've heard today that in Peabody's view, this was an unusual emergency situation. All the more reason to comply with the safety standards. The standards apply regardless of whether or not the situation's unusual, and they certainly apply in an emergency. I'll pick up where my colleague left off on the subject of the unwarrantables, unless the court prefers otherwise.
I just had a question, whether it's the agency's view that ventilation work includes plugging a borehole. Is there a term of art meaning to what ventilation work includes?
Well, it's the agency's view that it doesn't matter whether, in this case, it doesn't matter whether ventilation includes plugging the borehole, because the standard doesn't allow ventilation work when methane is at 1.5% or more in the return stream of air. But insofar as Peabody argues that plugging the borehole constituted ventilation. The judge found as a matter of fact that it wasn't ventilation. And it's the agency's view that that finding is supported by substantial evidence. That's correct. I think typically ventilation adjustments involve directing airflow in the mine, constructing temporary barriers to move air. And obviously, I think Peabody's focused on its attempts to eliminate the methane. And I think that encapsulates Peabody's wrongful approach here. Addressing the methane should not have been Peabody's goal. Peabody's goal should have been compliance with the standard and protecting them.
But you do think that's a question of fact, whether plugging the borehole is ventilation?
Yes.
It's not a legal determination.
I think that it's a question of fact and that the judge.
And it's supported by substantial evidence.
Yes. On the subject of the unwarrantables, I apologize, I'm a bit out of order here.
Do we look, I'm going to ask you the same question. Do we look to the reasonableness of the interpretation or the reasonableness of the safety judgment, or both?
I apologize if I'm misunderstanding the question. In order to determine whether or not there's an appropriate good faith defense to an unwarrantable finding, it's the behavior of the operator, whether or not that behavior was reasonable. I apologize if I'm not addressing the distinction, but here I think what the judge and the commission reviewed was the reasonableness of Mr. Butler's purported reliance on Mr. Farron, the reasonableness of his decision to allow drilling to continue in high methane. And both the commission and the judge found that no prudent operator.
Suppose we thought hypothetically that it was a very hard question whether you could run the electricity in these circumstances under the reg if you were doing ventilation. And, the greatest legal minds would say, gosh, this is really hard, 5149 question. And Butler's there in the middle of the night having to make the call.
Well, Judge Katsas.
It was sort of like a qualified immunity concept. Is that what we look to?
I'm forced to first say that, of course, that would never be the case because the standard is very clear. But conceding that in this hypothetical situation, it's a very, very close question. I think that the reasonableness of the standard is a reasonably prudent operator under those circumstances. And so reasonably prudent operator under those particular circumstances. So one could take into account the difficulty of making that call, I suppose. But again, that's not the case here. I'm happy to answer other questions on the unwarrantable findings. But I think I've made the point that
we can, the reason I'm asking is we can make our own judgment about the reasonableness of your friend's interpretive position. I mean, we do that under Auer and Kaiser. We make judgments like that all the time. But if we're talking about the reasonableness of the safety issues, could a reasonable operator have thought that under those unusual emergency circumstances, the best strategy is to try to plug the hole? Just feel much less comfortable in my ability to make that judgment.
I understand. And I think that the factual underpinnings that the judge relied on in determining that Mr. Butler was not behaving reasonably and that Peabody wasn't reasonable in attempting to plug the borehole rather than evacuating miners and disconnecting, de-energizing equipment and disconnecting it at the source. Those facts sort of compel the conclusion that it's not reasonable, and furthermore, they're supported by substantial evidence. All that's to say, Judge, the commission and the judge have reviewed this, and it is their, it's their position here that that was unreasonable. I hope that that's helpful.
I should have this at my fingertips, and I don't. I'm sorry, but commission found that this was less safe. Trying to plug the hole was less safe than evacuating.
Yes.
Did they find that safety judgment was unreasonable?
Yes. Yes, and just to draw attention to that fact, that it was less safe than compliance with the standard because it created the hazard. The running the drill introduced the ignition source into the high methane environment. And so in Peabody's purported effort to stem the flow of the methane, Peabody continued to create more hazard by introducing the energy into the high methane atmosphere.
I have a question about whether there's daylight between the Secretary's view and the Commission's view of C23. You've clearly argued in your brief, and you've argued to us today that C2 Romanet 3 prohibits all work other than the de-energization and evacuation mentioned in C2 1 and 2. The Commission said, sort of whether or not Romanet 3 prohibits, for example, adjustments to ventilation, it plainly doesn't allow energized work. Do you think that was incorrect or incomplete, or is there any error in the Commission's approach?
No, I wouldn't characterize it as incorrect. I think the Commission just declined to sort of reach the interpretive question that the Secretary is advancing, which is that the standard only allows the work detailed in subsections little Roman numeral 1 and little Roman numeral 2, excuse me. But I don't think that it was legal error. It just is that the Commission did not reach the full interpretive, or declined to reach the full interpretive question, I should say.
And for our part, do we need to go beyond what the Commission did?
We would ask that you do, yes.
Even though it's not necessary to resolve this case. And how about, do we need to resolve whether, this is maybe the same thing put differently, but whether the regulation permits ventilation adjustments when methane levels exceed 1.5% of return air split? It's actually a different question. Like the question about whether the standards accumulate or whether the 1.5 standard kicks in and displaces the.
Well, I think that in order to find that 1.5, that the no other work referred to in C2.3 refers only to work, or I'm sorry, refers to work other than evacuation and de-energization and disconnect. And it would involve finding that under C2, or I'm sorry, under C1 at 1%, the requirement, not the option, but the requirement that operators engage in ventilation control when methane is at 1%, or between 1% and 1.5%, I should say. I'm sorry, I've sort of rambled, but in order to find that C2.3's other work prohibition includes ventilation control, you would be required to
right.
That.
Right, but if going the other way, if Butler and Peabody were to prevail, one would have to accept the more limited view that the Commission took, and then also accept that the ability to adjust ventilation carried through when the methane levels exceeded 1.5.
If Peabody were to prevail on its theory that this was ventilation.
Right, and one would have to find that plugging the hole was ventilation.
Yes.
So all those three things.
Yes, and none of them are.
Ms. Maltz, the Commission, so the ALJ stated in its opinion that plugging the borehole was not ventilation work, but the Commission doesn't make any finding of that sort in its decision, as far as I recall. So how do we as a court think about that question? And can we review the ALJ's finding? Does the Commission decision, is it viewed as implicitly endorsing any finding that it doesn't explicitly disclaim?
I think that this court's approach to reviewing the ALJ's, in my view, factual finding that that plugging the borehole was not ventilation control, it is the same process that the Commission would have gone through, which is just reviewing it for substantial.
I'm sorry, can't hear you.
But we don't review the ALJ's decision. We review the commission's decision.
Yes, but the factual findings that the ALJ made are reviewed by the commission for substantial evidence and by this court then for substantial.
Even if they don't explicitly review them?
Yes. That's my understanding.
Is there a case you have that discusses
Not at my
a review
fingertips.
in this circumstance?
I apologize, not at my fingertips now.
So your view is the ALJ is the fact finder to the extent that the commission doesn't displace the facts that the ALJ found. Those are the facts
Yes.
that are implicitly incorporated in the commission's determination.
Yes. I could just briefly conclude. I would be remiss if I didn't emphasize what a outrageous, dangerous situation this was. And I'll just say that Peabody has suggested that the secretary's been hyperbolic in emphasizing the potential deaths of 6 minors, and it's not hyperbole to say that this circumstance could have resulted in at least 6 deaths and a horrifying explosion. So I just would like to emphasize that. Thank you.
Mr. Moore, if you'd like it, we'll give you a minute for rebuttal.
I wanted to address briefly the whole issue of whether it's ventilation work. If you had a seal along a return airway and it was breached because of roof pressures or something like that, and it was sending methane into the return, the repair of that seal would stop methane from coming in. It would be, without a doubt, ventilation work. So there, in my view, really isn't any different than plugging a hole. The other comment I had is there are 6 factors that the commission looks at for unwarrantable. They don't ever say reasonableness one way or the other, just that they looked at extent, duration, degree of danger, obviousness, knowledge of the condition, and abatement. And on some of these, as we've set out in our commission, because it wasn't supported substantially, how they were described. No other questions? Thank you very much.
Thank you both for your able arguments. The case is submitted.
Case number 22-7022. Sharon Michaels, appellant versus NCO Financial Systems, Inc. et al. Ms. Dennis for the appellant, Mr. Ullman for the appellees NCO and TSI, Ms. Burnett for the appellee Rubenstein.
Morning, Ms. Dennis.
Good morning, Your Honors. May it please the court. I would like to reserve 4 minutes of my time for rebuttal. Your Honors, the district court's decision below, there are several reasons for reversal of the district court decision below, but they all boil down to the misapplication of the summary judgment standard. In this case, looking at the facts, it's clear that Ms. Michaels presented to the district court below sufficient evidence to withstand summary judgment. However, the evidence contradicting defendant's false narrative was deliberately ignored. Prima facie proven claims were disregarded, and critical disputed facts and uncontroverted facts were resolved in the light most damaging to Ms. Michaels or disappeared altogether. The district court's primary reason for granting summary judgment is that basically the court says that Ms. Michaels failed to support her defenses with proper citations to the record. This Ms. Michaels' briefing below clearly shows that Ms. Michaels provided over 200 citations to record evidence in her briefing. Not only that, defendant's statements of fact also confirm the fact that Ms. Michaels did actually support her positions with citations to the.
Let me just focus on a couple of those that might be helpful. So for the FDCPA claim, which the district judge found was not timely, can you tell us what are the events that happened after June 27th, 2015? In other words, the year before the filing of the complaint, that give rise to an FDCPA violation?
Well, there are many. For one, the parties actually engaged in mediation where Transworld, one of the defendants, was still trying to collect the debt during the mediation, and that happened, I believe, on October 20th, 2015. Defendants also, up until dismissal initially tried to dismiss without prejudice, hoping to actually come back for a second opportunity to sue Ms. Michaels again. Whereas Ms. Michaels rejected that request to dismiss without prejudice, and instead, and defendants came back again and then decided to dismiss with prejudice. So defendants were.
Are you suggesting that simply maintaining a debt collection proceeding is a continuing violation of the FDCPA?
Well, I'm suggesting that defendants completed several acts after the court asked whether or not.
But those acts were all part of their debt collection proceedings. And a number of circuits have rejected the idea that simply maintaining a debt collection proceeding is a continuing violation of the FDCPA.
Well, in this circuit, the court has said that involving a litigation, and as opposed, and I believe it was Jung. I believe it was the case of Jung, where the court considered a ongoing litigation to be a continuing violation.
Which case is that?
Jung v. was a
Jung v. Mundy.
Yes.
Is that the case you're relying on?
Yes, I am. Where the court said the actual tortious continuation of a lawsuit actually does not, the violation doesn't accrue until after the disposition of the case.
Is that an FDCPA case?
No, it's not. It's involving litigation. It's involving an attorney, I believe in malpractice. I believe it was a malpractice situation where the court decided it involved an ongoing litigation. The court decided that the continuing of the litigation actually constituted a continuing violation, tortious violation under DC law. I believe, I apologize, I don't have the.
That seems like a more general principle, though, than whether such litigation would be a continuing violation under the FDCPA itself.
Well, if the court distinguishes between the FDCPA and a general continuing violation, then that you know.
Well, several circuits have done so.
Well, in this case, though, Ms. Michaels actually argues that the defendant's role in the actual litigation was actually concealed. She's also requesting tolling under the equitable concealment doctrine as well. Whereas she was not aware of any of the defendant's role in the actual litigation.
So relying on a discovery rule for that.
Not necessarily discovery rule, but more fraudulent concealment of activities by the defendants who did not disclose their role in the actual collection litigation to Ms. Michaels while the litigation was going on.
Right. So it's fraudulent concealment that tolls the limitations. Period.
Yes.
Is the theory, but for that to apply, there's a requirement of an affirmative misrepresentation by the defendants to prevent the discovery. And what is the affirmative misrepresentation alleged here that prevented Michaels from discovering the wrongdoing?
Well, they filed the suit and the wrongdoing of defendants.
The affirmative misrepresentation that put her off the trail, that made it so that she wouldn't have any
Well, they
reason to
filed-
think that there was wrongdoing.
They filed suit in the name of National Collegiate instead of their own name when they were actually prosecutors of the actual lawsuit in the collection action. So Ms. Michaels had no idea that they were the actual ones that were prosecuting the suit, and she was defending based on the fact that they had named National Collegiate and not Transworld and MRA as the actual prosecutors of the actual suit. National Collegiate had no involvement in the actual collection action at all. There was no communication from Transworld to National Collegiate, nor was there any communication between the law firm, Rubenstein, and National Collegiate. National Collegiate had no idea, the alleged creditor had no idea about anything that was going on in the actual lawsuit. So Ms. Michaels had no idea that defendants were actually steering and prolonging the suit. Ms. Michaels relied on the actual pleading in the actual collection suit, which states that National Collegiate is suing you for this amount of money, not Transworld and MRA. So with respect to that, and that is the reason why, I'm sorry, John.
Sorry, I'm not sure I follow that. National Collegiate owned the loan, right?
Well, it is, the case below was dismissed with prejudice because there is no National Collegiate or defendants could not prove that National Collegiate owned the loan or that there was a valid loan to be sued upon. The agreement that they presented below is not an enforceable agreement. It's an agreement made a makeshift agreement, DIY agreement that was produced primarily for litigation, and it was provided to the trial court.
I'm sorry, what DLY?
DIY, do it yourself agreement. They basically put several pages of the agreement together to make up a single agreement when it's actually not the actual agreement. And they've admitted to this in the statements of issues and dispute as well. So with respect to, there is no enforceable agreement in the record at all with respect. So the court the court granted Ms. Michaels, denied defendants' motion for summary judgment in the collection action because, for one thing, they couldn't prove an agreement because that is what Ms. Michaels argued. Well, National Collegiate could not prove an agreement, which is one of the defenses Ms. Michaels raised to the court in the collection action.
And the district court held that you don't have evidence or allegations of a willful violation of the DCL?
Yes.
What's the single best piece of evidence that you have that the defendant's conduct was willful?
The retainer agreement where they agreed to bring lawsuits in the names of absent creditors without disclosing that information to the actual debtors. Obviously, Ms. Michaels could have raised different defenses below had she known that it was Transworld that was bringing the lawsuit rather than National Collegiate. And defendants never disclosed that to Ms. Michaels, but the fact that they actually there's a signed, executed retainer agreement between the defendants where they actually agree to bring names and bring lawsuits in the name of absent creditors is a executed willful statement that we know what we are doing, which is what all DC law requires. DC law basically is that what constitutes willfulness is essentially is something that is inadvertent or not an accident. There's no evidence, no affidavits or anything in the record. The district court actually relied on Baylor. And Baylor v. Rubenstein, there was an actual affidavit. Rubenstein filed an affidavit in the record stating that his actions were not willful. They were inadvertent. Here, there's no affidavit, there's no evidence in the record, no affidavit in the record saying that the defendant's conduct below was actually inadvertent or accident. And it can't be because they signed a retainer specifically saying, we agree to bring lawsuits in the name of creditors who are not participating in the lawsuit. There's a signed retainer agreement in the records of them executing that both of them executed, where they actually agreed to do that. So there's no way to deny that the conduct is actually willful, especially given the very low standard in the DC under DC law, which states states only that it needs to be not, it needs to be either inadvertent or accident, which neither of them could do.
So sorry, your theory is that NCO should have brought the suit in its own name?
Well, they should, at the very least, NCO actually brought Transworld should have.
NCO Transworld should have been the named plaintiff?
No, Transworld actually prosecuted the suit. And Transworld, neither Transworld nor Rubenstein are the real party in interest, although they are the ones who actually prosecuted the suit. They brought the suit in the name of National Collegiate, just like they bring suits in the name of Capital One.
Which would be perfectly obvious if National Collegiate owned the loan. I know you dispute that, but NCO is a servicer, sub-servicer, right? They help people who own loans collect on them.
That's obvious. That's in dispute. The defendants have not proven what their role is, what their position is with NCO. However, they never disclosed any of this to Ms. Michaels, and neither of them, NCO and Rubenstein, are debt collectors. Neither of them are the real party in interest in the collection suit. So both of them filed the suit in the name of National Collegiate when neither had an interest in the actual debt they were seeking to collect in the suit. So and as I said, they never disclosed that to Ms. Michaels. With respect but just if I could just make one point, with respect to the DCL, there's a specific law that says that you cannot collect a debt in a name other than your true name. That's the DCL actually says that. So them bringing this lawsuit in the name of National Collegiate and not their own name when they are the sole prosecutors of the actual suit is a violation of the District of Columbia law. And they agreed to do that for several different creditors in the actual retainer agreements, in both the Dominion retainer agreement and also the Rubenstein retainer agreement, both of which are in the evidentiary record, and both of which Transworld admits to actually hiring and retaining and violation in unauthorized engaging in the unauthorized practice of law by hiring attorneys to actually bring these lawsuits.
Suppose one entity owns a loan. I'm just asking you a legal question here, divorced from the facts of your case. One entity owns a loan. The second entity services that loan. They're retained to provide administrative support to collect and such. And the third entity is hired as a law firm to prosecute a collection action. Who's the proper plaintiff? The named plaintiff. It's got to be the party that owns the loan. The proper plaintiff
is the party who has an interest in the lawsuit. J.H. Marshall says that debt collectors, like defendants, cannot bring lawsuits in the name of creditors and to litigate lawsuits in the name of creditors. That without engaging in the unauthorized practice of law. Well, there's several precedent, and also in banks. Banks, as far as a CPA violation, says that the unauthorized practice of law, Banks v. District of Columbia, says that the unauthorized practice of law is also a CPPA violation, which also differentiates that from Baylor v. Rubenstein as well. They're completely different facts. But the actual, the person who actually holds interest, I mean, the rules are clear with respect to who can bring a lawsuit. And that is the person who holds an interest in the actual dispute, who actually has a legal interest in the actual dispute.
So that would be the creditor. That would be the creditor, and the creditor hires a servicer and a law firm in Judge Katsas's example. And so it would have to be in the name of the person who owns the loan and by the lawyers. And then you're saying, but to the extent that the loan servicer is involved, either they're not the real party in interest and or they're not a lawyer and can't practice law.
Well, defendants are soliciting or selling legal services, basically. They're soliciting claims from creditors in direct violation of J.H. Marshall, DC law, and saying, look, we'll litigate your claim for you.
Or we'll arrange for someone who's barred to do it, who's
Right,
a
which is
lawyer.
also a violation of J.H. Marshall as well. Yes, or we'll hire attorneys, which is also an unauthorized practice of law under Rule 49 straight. You can't retain attorneys to actually do what you cannot do yourself. So that's also a violation and violation of the, of the CPA, because it's engaging in the unauthorized practice of law as well. So with respect to both, sorry.
Thank you.
Thank you, Ms. Dennis. We'll give you a minute. For
Thank
rebuttal.
you.
Morning, Mr. Altman.
Good morning, Your Honors. May it please the court. My name is Michael Altman. I'm here on behalf of NCO Financial and Transworld Systems. 2 minutes is going to be reserved for Lauren Burnett, counsel for Mitchell Rubenstein. There's a lot going on in this case, a lot of briefing, a lot of record, but I want to get to the main issue that has been flushed out for Your Honors in appellant's primary argument, and that is this argument that she's making that somehow the defendants in this case were acting as de facto plaintiffs in the underlying collection lawsuit. That is simply not true.
What about the related claim that they are engaged in the unauthorized practice of law under J.H. Marshall? If they're not the client, are they the lawyer? What are they?
So Transworld Systems, and prior to Transworld, NCO was the subservicer, as Judge Cass has correctly pointed out, is the subservicer of National Collegiate Trust. National Collegiate Trust does not have any employees. They work through their subservicers. Bradley Luke testified extensively to this in his deposition. And we also, in the record, there are multiple multiple amendments of the default prevention agreement by which the trust engaged NCO and later Transworld to be a subservicer. The retainer agreement that was referred to between NCO and Rubenstein explicitly states that the creditor is the client, that NCO is the agent of the client and is engaging the law firm on behalf of and to represent the creditor. And the record evidence is clear that NCO and Transworld were acting as a subservicer. The J.H. Marshall case deals with an antiquated practice, which does not exist anymore and has not existed for decades, where a debt collector would actually take an assignment of a debt, file suit in its own name, and go before the court in a pro se fashion to collect a debt. And so that is what the court chastised in J.H. Marshall, which I think is maybe from the early 70s. It's very old case. And in banks, likewise, you had a non-lawyer practicing law before a court. NCO and Transworld Systems engaged Mitchell Rubenstein, a real law firm, to act as counsel for National Collegiate. NCO and Transworld Systems, unlike J.H. Marshall, never stood before a court, made any filings before a court, either on their own behalf or as National Collegiate Student and Trust. The owner of the loan in the underlying collection lawsuit was National Collegiate Trust. The record evidence makes clear that there was an assignment from Chase Bank to National Collegiate Trust, and Mitchell Rubenstein and Associates was their lawyer. It's not very complicated, though plaintiff has attempted to make this a very complicated issue. But at the end of the day, the heart of the argument that plaintiff is presenting to the court is simply untrue. There was no masquerading by the defendants as the real party at interest. The real party at interest was National Collegiate Trust.
In terms of the merits of the underlying litigation that Michaels is challenging in the Superior Court, why was the claim against Michaels timely? Timely? Why was it not time barred by statute of limitations?
Because, Your Honor, there were payments made into 2012, which was presented both with record evidence of payments as well as a supporting affidavit in the lower court. Therefore, it was timely. I believe there were questions posed to Ms. Michaels in her deposition to identify exactly when all of her payments were made. There was discovery issued to her to identify when all payments were made, and the response was non-responsive. So the only record evidence is that there were payments made into 2012. But I also advise the court that any claims relating to that are time-barred because the lawsuit was filed over a year prior to the instigation of this lawsuit.
Sorry, which FDCPA claims are timely? Maybe I misheard you.
I'm sorry. None of plaintiffs' claims under the FDCPA are timely because there were no discrete acts by any of the defendants within 1 year prior to the filing.
So let me ask you just about one discrete act, which was the letter that Dominion sent, the collection letter that Dominion sent late June 2015. That's in the limitations period.
And
they're not before us, but I'm wondering if why isn't there at least a plausible basis for attributing Dominion, that act by Dominion, at least to, TSI, which retained Dominion as a contract. It's on behalf of the client, which owns the loan, but TSI retains the ability to control Dominion and view pleadings and things of that nature. So it looks a little bit like Dominion is the agent of TSI as well as the agent of the party that owns the loan.
Your Honor, the Fair Debt Collection Practices applies to acts of a debt collector. And Dominion, you're correct that Dominion here is the debt collector that issued that letter. Dominion is an independent contractor. The retainer agreement makes that clear that they are an independent contractor. They are responsible for following all applicable laws, including the Fair Debt Collection Practices Act. If the plaintiff believed that Transworld was somehow responsible for that, there is not a per se liability that would attach to a creditor or something. Creditor typically is not subject to the Fair Debt Collection Practices Act, only a debt.
There's a clause in the retainer agreement that says TDM reserves the right to review any written communication you, the law firm, deem appropriate to send a debtor.
They may reserve the right, Your Honor, but that does not give them control over Dominion. The plaintiff will have to show more by way of actual control over Dominion. They simply have not presented any evidence whatsoever that Transworld exerted that type of control over Dominion. That is
control to show an agency relationship
and establish vicarious liability,
which you don't think. And why wouldn't that arise by operation of the retention agreement?
I think the agreement, the plaintiff would have to show that there was something beyond the agreement where in practice, there was actual control exercised over that letter. I would also like to add too, that the complaint does not even allege vicarious liability. These are knee-jerk allegations without any support, but there's no vicarious liability alleged against Transworld, nor is there any supporting document.
Just again, on the timeliness of the underlying suit against Michaels in the Superior Court, why is the last payment the date triggering the statute of limitations? Do you have any case support for that, or statutory support?
That
her payment was the date from which the limitations were.
I don't have it in front of me, Your Honor, but typically the statute of limitations is renewed by an expression that one owes the debt, and that is typically accomplished by a payment. There's an acknowledgement of the debt. But again, it's our position too that claim is time barred, as there was no demand for payment made within 1 year of the prior to the filing of the suit.
And I have one question that's sort of the inverse of the agency questions that Judge Katsas was asking, which is, we have an affidavit asserting personal knowledge regarding Michael's loan and the chain of assignments. It seems that the declarant was familiar with NCO and TSI's record keeping, but not necessarily JP Morgan's practices. How can we credit that as that personal knowledge in that declaration?
Well, again, this would go to the extent that the lengthy transcript of Bradley Luke's deposition, where he testified as to the trading and personal knowledge with First Marblehead, who was the servicer of the trust. And again, these are assignment documents for which they are custodians of record. And so the personal knowledge of the documents is related to understanding the chain of assignment. But NCO and TransWorld were not only the servicers, but also the custodian of record, for which there was requisite training so that they understood that chain of title. But this was a custodian of record presenting documents.
All right. And I gather we're going to hear briefly from Ms. Burnett. Thank you, Mr. Altman.
Sorry about that. Good morning. May it please the court, my name is Lauren Burnett. I represent Mitchell Rubenstein and Associates, and I'm thrilled that you asked questions about the statute of limitations underlying with regard to the collection suit, because that brings me to an important point that Judge Hogan didn't touch on, but that we certainly preserved for your honors to hear. Before I get to that, though, if I can add a little bit to what Mr. Altman said about the statute of limitations on the underlying loan. The name of the case escapes me. I think it may be Woods. But the type of loan was such that once the loan was accelerated, then all of the remaining payments became due. And essentially each payment carries with it its own statute of limitations. So you have to choose whether to continue to allow this loan to remain delinquent, and you kind of, chip away at how many payments are remaining, or you can choose to accelerate the whole thing and seek the entire outstanding balance. And that's what made the underlying collection lawsuit timely. This is important because I'm an attorney and I'm up here talking about it. Mitchell Rubenstein is an attorney. He and his associates looked at this account and decided under statutes of limitations governing this type of lawsuit whether or not it was timely. The only person in this lawsuit who has been claiming that there was something faulty with the underlying lawsuit, whether it was untimely, whether it never should have been filed in the first place, whether there was probable cause, whether this was an appropriate assignment, is Sharon Michaels, who by her own admission is not an attorney. In this lawsuit, she is a consumer. And under the FDCPA, we treat consumers as though they are all the hypothetical least sophisticated consumer, which other circuit courts of appeals have determined would fall around a 6th grade reading and comprehension level. So we're really talking about a very low bar for very high protection of consumers. This is an important aspect of the FDCPA. But when we're talking about a licensed attorney's exercise of the profession of law, for which he holds a license issued by the District of Columbia that gives him the permission to come before your honors and practice law, then I think, and I would argue to the court, that Judge Hogan also could have granted summary judgment in Mitchell Rubenstein's favor, because we had no expert testimony to talk about what the standard of care governing his conduct was, what he did wrong, how he deviated from that standard of care, and what he should have done. And I submit to your honors that without that, there are aspects of the FDCPA that are applicable to attorneys in the practice of law for sure, that would not require expert testimony, just like a malpractice claim. This is not one of those. if your honors have any questions, I'm happy to.
Nope. Thank you, Ms. Burnett.
Thank you.
And I think that I offered Ms. Dennis a minute for rebuttal. If you'd like it, you needn't take it if you don't want to.
Thank you, Your Honor. First, I want to state that PSI has already admitted that the loan was accelerated before they actually received the loan, and it was in as of March 1st, I believe, in their payment history, the loan was already in default. So as far as like the payments that were made, the loan was already in default, and that statute of limitations had already ran. So there was no late acceleration referred to by Rubenstein, by my colleague from Mitchell Rubenstein and Associates. Also, there is no affidavits or anything in the record proving PSI's subservicer status. Rubenstein, MRA admits that TSI was his client. He had no dealings whatsoever with a National Collegiate. Transworld in its own, also with respect to J.H. Marshall. J.H. Marshall states that advised creditors says it's the unauthorized practice of law for creditors for a debt collector to advise creditors when to bring suit, solicit or receive assignments of claims or debts for collection, which contemplates or authorize the enforcement of collection by suit brought in the name of either party by the attorney at law. So either the creditor or the debt collector. It doesn't matter which name it's in, it's still the unauthorized practice of law. J.H. Marshall is not the only, we are not the only jurisdiction that actually holds this. Ms. Michael cites several in her briefing with respect to that.
All right. Thank you, Ms. Dennis.
Thank you.
The case is submitted.
Thank you.
Thank you all.